Chapter 8, Customer Protection Act and the Competition Act. So in this chapter, we're going to talk about the Competition Protection Act, which applies to the activities of real estate brokerage. We'll identify representation that could be in violation of the Customer Protection Act. Explain the various remedies for the customer under the Customer Protection Act and the consequence of the violation of the Act. Demonstrate a knowledge of how brokerages must conduct their business in compliance with prohibitions against fair competition and the price fixing. Identify and discuss very specific provisions in the Competition Act that directly relate to the false and misleading advertising and describe the requirements of the Canada anti-spam legislation as it relates to the registered advertising and marketing. So coming back to the Customer Protection Act and the Competition Act. So first, the Customer Protection Act. The Customer Protection Act came into effect in 2005 with expanded rights and remedies for customers and businesses. The Act consolidated six existing customer protection laws, which includes the Business Practices Act, the Customer Protection Act, the Customer Protection Bureau Act, the Loan Broker Act, the Motor Vehicle Repair Act, and the Prepaid Service Act. The Customer Protection Act is designed to prohibit unfair practices in sale to the consumers. Although the Act does not affect representation made during the course of selling real property, it does apply to real estate brokerage when representations are made during the course of selling goods and services to consumer. A seller or the buyer who complains under this act that there has been unfair practice in the selling of the goods and services may cancel the contract, sue for damages, or file a complaint with the Customer Protection Branch of the Ministry of Government Services. So this act does not apply to representation about the real property. The type of contract that may be cancelled and therefore be a service or representation or a representation agreement. So again, to recap, the Customer Protection Act is designed to prohibit unfair practices in sales to consumers. Although the Act does not affect representation made during the course of selling real property, it does apply to the real estate brokerage when representations are made during the course of selling goods and services to consumers. Seller or buyer who complains under this act that there has been an unfair practice in the selling of the registered services may cancel the contract, sue for damages, or file for complaint with the Customer Protection Branch of the Ministry of Government Services. As stated above, this act does not apply to the representation of the real property. The type of contract that may be cancelled would therefore be a service or representation agreement. So there's a very clear distinction between what a Customer Protection Act can cover in the case of real estate business. So what it basically means is the act does not apply to the representation about the real property, but but the type of contract that may be cancelled would be a service agreement or a representation agreement. So looking at the exceptions to the Customer Protection Act, the one of the exceptions says that the consumer transaction for the purchase, sale, or lease of real property, except transaction with respect to the timeshare agreement. So again, timeshare agreement is covered under the Customer Protection Act. And the consumer transaction regulated under the Residential Tenancies Act. So those are the ones for which there is exception. Also, the agreement which can be subject to other acts is the REBA 2002. Further, other general provisions are also limited in the relevance to real estate, most notably those concerned with the future performance contract, as well as internet direct or remote agreement. Real property, as such, is not included in the definition of goods, but chattels and chattels that become fixtures are included. Real estate practitioners are affected when providing services, listing or representing buyers, appraising and arranging financing. For example, if a listing or a buyer representation agreement is obtained through the use of an unfair practice as defined by the Act, the seller is entitled to risk in the contract. So like I mentioned, say the Consumer Protection Act doesn't apply to the real property, but does apply to the representation or the service agreement. It also applies to the various chattels and the chattels that become fixtures, and also to the timeshare. Unfair practices. The unfair practices are grouped under the false or unconsignable consumer representation. A false, misleading, or deceptive consumer representation includes includes a representation that the goods or services have sponsorship, approvals, performance characteristics, and benefits, or quantities that they do not have. The person who's applying the goods and or services has sponsorship approval, status affiliation, or connection that he does not have. That a specific price advantage exists when it does not exist. That misrepresentation that misrepresentation the authority of a salesperson, representative, employee, or the agent to negotiate the final terms of a proposed transaction, and that the proposed transaction involves or does not involve right remedies or obligations if the transaction is false or misleading, and that uses exaggeration, innuendos, and ambiguity as to the material fact, and fails to state a material fact if such use or the failure to deceive or tend to deceive, that misrepresents the purpose or intent of any solicitation of any communication with the consumer. So so again, with regards to unfair practices, there is also this notion of a false, and there is notion of a unconsignable customer representation. A false representation includes the false sponsorship, approvals, performance characteristics, benefit, um, characteristics of a good or services that it doesn't possess specific price advantage exists but doesn't exist. Misrepresentation made with authority of salesperson representation agreement, or employee agreement to negotiate the final terms of the transaction. Proposed transaction involves or doesn't involve right remedies and obligations. Use exaggeration, innuendos, and ambiguity to the material fact. The unconsignable customer representation made in the respect of a particular transaction is determined by various considerations. A consignable consumer representation occurs if the person making the representation or the employer knows or ought to know that the consumer is not reasonably able to protect his or her interests because of his or physical infirmity, ignorance, illiteracy, inability to understand the language of the agreement, or the similar factors. This falls under unconsignable consumer representation. That the price grossly exceeds that at which similar goods or services are readily available to the like customers, that the consumer is unable to receive substantial benefit from the subject matter of the customer representation, that there is a reasonable probability of the payment of the obligation in full by the consumer, that the proposed transaction is excessive, one-sided in the favor of someone other than the consumer, and the terms and agreement of the proposed transaction are so adverse that the consumer has to be inequitable, that he or she is making a misleading statement of the opinion that the consumer is likely to rely upon to his or her detriment, that he or she is subjecting the consumer to undue pressure to enter into the transaction. Compliant procedures. The customer may complain of unfair practices, for example, in the case of a seller who claims to have signed a listing because of the undue pressure. Says that several alternatives are available in such cases. The seller may risk cancel the contract, which would terminate the listing upon giving a written notice to the agent personally or by registered mail within 6 months after the agreement was signed. The seller is entitled to any remedy available at law, including damages that may be ordered by the court for fraudulent or negligent misrepresentation, and for the breach of the duties by the agent. If rescission is not possible, then this property is sold, and the seller can recover the amount of the commission paid that exceeds the fair value of the services or damages of both. So, wi- with regards to essentially the unfair practices can be grouped as false and unconscionable customer activities, and the complaint procedure is is that the customer may complain of unfair practices. Um, for example, in the case a seller who claims to have signed a listing because of the undue pressure. So several alternatives are available in such a case. The seller may rescind or cancel the contract, which would terminate the listing upon giving a written notice to the agent personally or by registered mail within 6 months after the agreement was signed. Seller is entitled to the damages available at law, and if the rescission is not possible, that the property has been sold, the seller can recover the amount of commission paid that exceeds the fair value of the services damages of both. The court can also award exemplary or punitive damages. The seller has another option, or involving filing a complaint with the Customer Protection Branch of the Ministry of Government Services. An investigation, search of witness premises, and removal of records for copying and other administrative procedures may follow. Such a complaint may include the issuance of an order by the Director of Customer Protection Branch requiring compliance. The breach of the Act or the failure to comply with the director order may result in a prosecution. So again, a customer complaint arising from the representation and action of the real estate practitioner are now largely fall under the jurisdiction of RECO, Real Estate Council of Ontario. RECO assumed responsibility for the administration of the Real Estate Business Broker Act in 1997. The council mandates focuses primarily on customer protection and administration of regulatory requirements. With regards to the competition agreement, the the competition agreement is a federal statute addressing many forms of competition. The act is intended to promote fair competition and efficiency in the Canadian marketplace. The legislation provides a framework for selected basic principles involved in the conduct of a business throughout Canada, and apply with a few exceptions to all business enterprises. The Act covers criminal as well as civil law matters. The 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 offences which are criminal relate to price fixing, bid rigging, and misleading advertising. Civil law issue includes mergers, abuse of dominant position, activities, um, activities to substantially lessen competition in the marketplace, exclusive dealing, hindering and preventing consumers from dealing with other suppliers, and refusal to deal, obstructing adequate supply of product to personnel carrying out a business. So again, to recap, the Competition Act has both criminal as well as civil matters. The criminal matters include price fixing, bid rigging, and misleading advertising. So again, note that the misleading advertising falls under can fall under criminal offense. So civil issues include mergers, abuse of dominant position, exclusive dealing, and refusal to deal. Director of Investigations and Research, head of the Customer Bureau, is responsible for administration and enforcement of this act. The Bureau falls under the responsibility of Industry Canada. During 1988, the Competition Act gained prominence in the organized real estate relating to the operation of real estate boards and associations. Under the application of the Attorney General of Canada, an order of prohibition relating to the Customer Act was issued in December 1998. The order was issued between the federal court and the 10 real estate boards named as the respondent. The CREA, wishing to enter into the prohibition order, signed agreement with the provincial associations and the local board in advance of the order being issued. All members of CREA are required to undertake certain activities such as provide new members in 1995 with a copy of the compliance guidelines, comply with the Competition Act, and specific paragraphs, publish a copy of the order in and with the MLS listing once a year, provides CREA the names of any members whose membership in a board or association is terminated or refused, along with the particulars A compliance guidelines was developed by CREA to assist real estate boards and their members in recognizing competition problems that can result in serious criminal or and civil penalties. Bill C-20. In March 1999, Bill C-20 was proclaimed into law. This law now represented a significant overhaul of the Competition Act with amendments concerning deceptive telemarketing, disclosure by telemarketers, Competition Bureau, interception of private communication in serious situations with judicial authority, and protection of individual identities for persons reporting offences. In addition, C-20 provided a maximum statutory limit of 10 years for prohibition orders issued after the proclamation of the bill. The federal court subsequently ruled the prohibition order involved real estate ended in 1999, the day amendment to the Competition Act was proclaimed. Principle of competition. The General Assembly of the CRE adopted the Principle of Competition document to ensure that the overall message of the competition law remains in the forefront of real estate board decision making. The document is designed both as a compliance and as an educational vehicle. Is the principle of competition designed as to assist the real estate board and does not apply to the individual practitioners as members of the real estate board. Bylaw and rule amendments are required for individual boards to adopt these principles. The board of directors of the CREA also approved a second necessary document called entitled the Pledge of Competition. This pledge broadly encompasses the scope of the principles and interpretation, and say that the member board and the association of the Canadian CREA support free and open competition. We believe in the principle embodied in the Competition Act of Canada. Therefore, we adhere to the code of conduct, which includes the following standards: commission rates or the fees member charge for services offered to the public, and the division of those services among cooperating members are solely the choice of those providing the services. The brokerage may offer any any variety of services, exclusive open MLS listing. Boards and real estate associations accept MLS listing regardless of the price, commission rate of fees, and the division thereof. Advertising by members or non-members is subject to discretion of the individual as long as it's honest and lawful. The business relationship between broker members, their salesperson, and non-members is for them to figure out. With regards to the board and association membership, members may choose for themselves to work full time or part time as long as they remain available to serve the public on a regular basis and provide provincial and every legislation that does not otherwise authorize the limitation of such choice. All members are required to meet uniform and reasonable financial and educational standards. They are required to demonstrate integrity and character necessary to protect the public. So again, there is a principle of there's principles of competition that are more of a compliance as education vehicle, and again there is a pledge of competition, which encompasses the scope of the principles and interpretation. Advertising guideline. The Competition Act, while enforcing various matters, prohibits misleading advertising and business practices in the promotion of a service or supply and use of a product. The Industry Canada is responsible for the act, with enforcement uh, done by the Competition Bureau. So the Competition Act, along all the dictating procedures for a number of trading activities, is particularly broad in its approach to the false or deceptive advertising practices. No person shall, for the purpose of promoting directly or indirectly the supply or the use of a product, or for the purpose of promoting directly or indirectly any business interest at any by any means whatsoever, knowingly or recklessly make a representation to the public that is false or misleading in a material aspect. The following are three important factors involving offenses under the statute. The term material refers to any information which could affect the purchasing decision. In other words, any representation that might influence a customer in the marketplace can fall under the act. So, to repeat, no person shall, for the purpose of promoting directly or indirectly the supply or the use of a product, or for the purpose of promoting directly or indirectly any business interest, by any means whatever, knowingly or recklessly make a representation to the public that is false or misleading in a material respect. That is false or misleading material respect. Proof of intention to deceive is not necessarily a prerequisite for the charge under the statute. In fact, it is not a proper defense to argue that the misrepresentation was never intended. The definition of misleading is deliberately expanded to include non-literal impressions given by the advertisement. This is commonly referred to as the general impression test. The Canadian CREA. The CREA publishes an informative booklet with particular emphasis on the false and misleading advertising, deceptive marketing practices, and enforcement of applicable portion of the Competition Act by the Marketing Practices branch of the Bureau of Competition Policy. The publication is entitled Misleading Advertising Guide. Also provides useful guidance for advertising by CREA for the purpose of trading in real estate. An expert for this publication has been printed on the following pages for information purposes only. This material was developed based upon the publication and interpretation and opinion currently at the time of publication, and is subject to changes. Individuals are advised to assess current information from the respective authorities, the broker, and our legal counsel prior to the development of any marketing material. General parameters. The issue of accuracy and clarity are fundamental to all advertising. The select topics are below. So to kind of recap here, the term material refers to information that could affect the purchasing decision. Proof of intention to deceive is not necessarily a prerequisite for the statute. In fact, it is not a proper defense to argue that the misrepresentation was never intended. However, the proper defense can be due diligence to correct the error. The definition of misleading is expanded to include non-literal impressions given by the advertisements. General parameters. The issue of accuracy and clarity are fundamental to all advertising. For example, the abbreviation. The cost of a classified advertising is a primary rationale for the use of abbreviations. Although a host of quotes and contractions are used when completing the MLS listing, abbreviations are becoming more widespread in advertising. So long as the abbreviations do not confuse or mislead, they should be fine. Advertised price. Competition Act does provide sales above the advertised price in case of a private real estate transactions. Specifically, the actual reference in the Act excludes sale of property or on behalf of the person who is not engaged in the business of dealing in that product that private real estate sells. However, other representation concerning price come under scrutiny. Any reduction or other alteration of the price should be clearly identified and not be materially misleading. Further, the suggestion of the bargain that is not substantiated can have a legal ramifications. Human Rights Code. A salesperson in the advertising property cannot set out specifics for a specific cannot set out preference for a specific class or a group of individuals that are specifically forbidden under the Ontario Human Rights Code. Competition. The Competition Act outlines the basic rules for the operation of contests. Section 59 focuses primarily on the adequate and a fair disclosure of certain key facts, the approximate number or value of the pieces included in the contest, of the prize included in the contest, allocation of the prize by the region, chances of winning, whether or not a skill test is required, place where the contest rules can be obtained, the closing date, and any unusual restrictions or conditions relating to the promotional context. Practitioners are strongly encouraged to seek expert advice in the development of contests, particularly those involving the game of chance, to ensure compliance with the of the lottery provisions of the criminal code and other applicable provincial and federal statutes. Coupons and market evaluation certificates. Certificates and coupons must clearly identify the service being provided. Disclaimer and limiting conditions should be consistent with the overall impression conveyed. Fine prints or fine print or disclaimers. Classified advertising and other types of promotional material often contain additional information in small print that either qualifies or otherwise expands the message being conveyed. Real estate practitioners, in order to save space, may relegate certain information to the fine prints. Generally, this text will not arouse concern if it is additive and complementary to the main message. However, if the fine print is in any way contradicts or otherwise limits the general impression conveyed by the main message, then a violation of the Competition Act may arise. Disclaimers are frequently found in the fine print. As a rule, such disclaimers should not contain information that materially limit or contradicts the main text or have any significant effect on the general impression being conveyed in the act in the advertisement. The Canadian Code of Advertising Standards, Clause 1D, provides the guidance on the issuance of disclaimers and asterisk fine print information. The size of fine print also comes under scrutiny by the Director of Investigation and Research of the Competition Bureau. Fine print should be clearly visible, readable, and related to the print size used throughout the positional advertisements, and take into account the need of targeted audience, which while general impression remains the ultimate test. The director has indicated that the accessibility of 7-point point size as a minimum. Free offering. If a product or service is advertised as free, then such an offering shall not include any condition or the requirements that the prospective customer would be unable to comply with. The Director of Investigation and Research also addresses the 2-for-1 offering by citing the following example as a false representation. By buying one real estate lot, receive your next lot absolutely free, where the price of the first lot is inflated to cover the cost of the free lot. MLS. All MLS listings are viewed as advertisements and consequently fall under the Competition Act. All MLS listings are viewed as advertisements and consequently fall under the Competition Act. All members must ensure that the listing information is accurate and correct. As a rule, the real estate practitioners are advised to include nothing on the listing agreement that cannot be verified by source documentation. Information concerning items such as lot size, legal description, mortgage financing, taxes, chattels, and features, current zoning, rentals, to mention a few, come under scrutiny. In fact, inaccurate representation are normally not only actionable under the federal statute but also under the common law, as the innocent or fraudulent misrepresentation. The importance of accurate listing information and and representation relating thereto is obviously a major factor in broker liability in the marketplace. Although lacking definitive Canadian research at this time, statistical information from the United States underscores the legal entanglement between the buyers and sellers, and that undoubtedly arise from the matters pertaining to the accuracy and adequacy of the listing information. In fact, the majority of the claims involve the buyer as a claimant. Personal identification guidelines, procedures, and specific wording regarding identification of the broker and salesperson in relation to the promotional material is identified in Robert Thorne 2. No erroneous impression can be conveyed when a picture or illustration accompanies and the forms for part of the overall advertisement. For example, if the home is being sold as between 150 price range and the house featured in the advertisement is a model other than that offered, then the offense can arise under the Competition Act. In case of illustrations, it's common to use asterisk statements in the new home sales, such as illustrations are artist concept only, price and specifications subject to change without notice, limited quantities available in some price ranges, illustration only, prices and specifications subject to change without notice. If the If the complaint is lodged under the provision of the Competition Act, the content of such statement, including the respective sizes and location in relation to the advertised information, would also be taken into consideration by the Director of Investigation and Research. Promotion claims. Real estate practitioner must be careful to correctly represent any claim concerning personal performance level. As with any other area of advertising, the general impression of the marketing piece and the actual test must agree, and the statement must be accurate and not misleading. The caution is strongly advised when contemplating claim statements such as the best in the area, the first in the production, the most popular choice, the most respected, the largest, etc. While such claims may be substantiated, the Director of Investigation and Research with regards to each but while such claims may be substantiated, the Director of Investigation and Research will regard each claim on its own merit, ensure that the performance claims are correct and accurate. Summary. So advertising has become an increasingly complicated facet of real estate trading. Salesperson must consider legal issues and statutory regulations that surround the presentation of the property and the provision of service in the marketplace. In the future, the industry will naturally develop additional guidelines and utilize more complex disclosure forms to address the needs of expanding and sophisticated consumer market. Now coming on to the Canada anti-spam legislation. Canada anti-spam legislation received royal consent in 2010 and became a law in 2014. This is an act to promote the efficiency and adaptability of Canadian economy by regulating certain activities and discourage reliance on electronic means for carrying out commercial activity, and to amend the Canadian Radio, Television and Telecommunication Commission Act, the Competition Act, the Personal Information Protection and Electronic Documentation Act, and the Telecommunication Act. So, a commercial electronic message is just maybe described as any electronic message that encourages participation in the commercial activity, regardless of whether or not there is expectation of a profit. As noted, a commercial activity is broadly defined and included, among other things, activities such as offering for properties for sale, advertising and promoting goods or service, or a person. An electronic address is an email address or telephone account, or instant message account, or any other similar forms. Messages sent to other users on social media such as this qualify as a same as an electronic address. CASL does not apply to the Twitter posts, Facebook wall posts, website blogs, two-way voice communication between individuals, and the fax and voice recording sent to a telephone account. However, the legislature should be mindful of the requirements of the National Do Not Call list. So again, CACL does not apply to Twitter posts, Facebook wall posts, websites, blogs, two-way voice communication between individuals, and faxes and a voice recording sent to a telephone account. Again, we should be mindful of the National Do Not Call list. Prohibition. So before sending a commercial electronic message to electronic address, the sender must obtain the consent from the recipient, identify himself or herself, and provide a means for the recipient to withdraw consent. Consent can be written or implied. However, if challenged, the onus is on the sender to prove that he has obtained the consent to send the message. When requesting the express consent, silence or inaction on the part of the intended recipient cannot be considered as providing consent. Express consent must be obtained through an opt-in mechanism rather than an opt-out. A pre-check box for consent is not permitted, and this would assume consent where it was not intended. When requesting express consent, among other things, the following information must be included. The specific purpose must be clearly identified. The name of the person requesting consent, or the person requesting consent on behalf of the person. Both persons have to be identified. Contact information of the person requesting consent, including the physical address and either telephone number, email address, or a website. In case of referral, consent from the recipient is not required, provided that certain conditions are met. The referral must have been made by an individual who has an existing business relationship, an existing non-business relationship, a family relationship, or a personal relationship with both sender and the recipient. Full name of the person making the referral, and the statement that the CEM is being sent as a result of a referral must be included in the CEM. The CEM must contain sender information and an unsubscribe mechanism. Consent can be implied in situations where there is an existing business relationship or non-business relationship in the last 2 years. The recipient of CEMS has conspicuously published his or email address or has disclosed her electronic address. However, where the recipient has conspicuously published or discloses her electronic address, the CEM can only be sent if the content of the message relates to the recipient role, functions, duties in an official or a business capacity. The recipient, when providing a business card or publishing his or electronic address on a website, did not state that he or she did not wish to receive CEM at that address. So again, to recap, before sending the CEM, we need to obtain the consent of the recipient, identify ourselves, and provide a means for the recipient to withdraw consent. So again, with regards to obtaining consent, there can be express consent. There can be the case of a referral, in which case the referral should be made by someone with whom there's already a business or non-business or personal relationship. The full name of the person making the referral, and the statement that the CE was sent as a result of that referral, and the CE must also contain the sentence information and the notice to and the mechanism to unsubscribe. Also, the consent can be implied. So, like there is an express consent or by the consent by referral or the implied consent. In the case of implied consent, it happens when the person has conspicuously shared his email address, and then there's existing business relationship or non-business relationship in the last 2 years. In case of a conspicuous sharing of the email address, the CM can only be sent if it relates to the business role, or and the recipient has said that has not said that he doesn't want to receive the CEM. In case of existing business non-business relationship, an existing business relationship exists when two persons have been doing business together in the past 2 years. For registering, this could mean the purchase of property, a listing agreement, or a buyer representation agreement. In case of inquiry for the licensed services, the time limit for sending CEM by without express consent is 6 months from the inquiry. So either there is an existing business relationship where for the purchase of property or listing agreement, or if there was an inquiry, in which case the CM can only be sent for six months past inquiry. The same goes for the installation of computer programs. Section 8 of the CASL applies it when a computer program or an application is installed on the computer. The purpose for which the consent is being sought, identification information of the person, and the function and the purpose of the computer program should be provided. Now, there's the hefty penalties for violation. It's about 1 million for an individual and up to 10 million for the businesses. I think with this we are done with Chapter 8. To summarize, the Consumer Protection Act is designed to prohibit unfair practices in the sale to consumers. This act does not relate to representation while selling real property, but does apply to selling of goods and services. Like approaching a customer regarding representation agreement. So again, the CB does not relate to the representation while selling the real property, but does apply to selling of goods and services, like approaching a customer regarding representation agreement. If a representation agreement is obtained through the use of unfair practices, the seller is entitled to risk in the contract. The seller may claim that he has been a victim of unfair practice, undue pressure while signing the listing agreement, and has certain remedies under the Act. The Competition Act covers both criminal as well as civil matters. Misleading advertising is false under the criminal matter. Various guidelines are provided to assist registrants in ensuring compliance with the Act with regards to false misleading advertising. Section 52 of the Act is focal to real estate brokers. Sets out the important provisions regarding concerning false and misleading advertising. A multiple listing agreement is reviewed as an advertisement for the purpose of the Competition Act. And the Canada Anti-Spam Act prohibits sending of commercial electronic messages unless the person to whom the message is sent has consented, either express or implied consent. I think with this we're done with Chapter 8. Thanks for your time.